Hello, 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 hello.
John, Senior Advocate, Delhi High Court. Thank you. So as most of us would know, Ms. Rebecca John is a noted criminal lawyer, and she is also the first woman to have been designated senior from the criminal side. She's appeared in a number of high impact and prominent criminal law matters, as most of us would know, the Arushi Talwar case, the Delhi bomb blast of 2005. As most of us would know. And ma'am, if I'm not mistaken, you were associated with Mr. Dinesh Mathur, who's a noted criminal lawyer himself. And you also worked with the J.S. Verma committee, which is constituted to suggest amendments to the criminal law with respect to offenses relating to women. So Ms. John will be, is with us this evening to speak on the Hashimpura Massacre of 1987. Just a brief insight for the benefit of those who are not really familiar with the Hashimpura Massacre case. So the Hashimpura Massacre witnessed the killing of 42 Muslims in a town in Uttar Pradesh, in Meerut, called Hashimpura. Almost 28 years after the killing of these said people, a trial court, the Tis Hazari court, acquitted the 16 Provincial Armed Constabulary personnel who were accused of having committed this offense. So what adds to the utter dismay that is generally associated with this case are some really intricate facts related to this case. So prosecution began, if I'm not mistaken, almost 17 years after the crime was mistaken. The trial was pending for another 11 years almost, which ultimately resulted in the acquittal of those who were accused in this matter. Ms. John has been associated with the case for since almost 2004, ma'am, if I'm not mistaken. Yeah, and the matter now awaits hearing in the Delhi High Court. An appeal has been filed. I think several appeals have been filed, and it's been listed for hearing on 31st of March this year. So without much ado, ma'am, I would like you to take over and begin with, start sharing your insights on this case.
You know, your series is called Great Cases, and I wish I could put the Hashimpura Massacre within the category of great cases. It's actually the most tragic of all cases. And I wish the outcome had been different. Very often, people ask me, what is it that takes witnesses to come and testify in cases of which has such gory facts? And I'll just therefore put these facts together so that you get an insight as to how horrific this incident was, and really how we let down a small mohalla near Meerut, collectively let them down by not ensuring that the people who were really responsible for this massacre were not convicted. So the timeline is like this. In May 1987, there were communal riots which broke out in Meerut. As part of the law and order comb-up operation, the Uttar Pradesh police had put in place the local police, members of the PAC, which is the Provincial Armed Constabulary. The army was called in when the situation went out of control. And one of the units posted there from the PAC was what was called the C Company of the 41st Battalion. This really is the C Company of the 41st Battalion is really the company from where the 19 accused were zeroed in. On the 21st of May, the riots became it became more serious. In the incidents of violence that were reported from the area were more serious. And so on 22nd of May, which was a Friday, the PAC arrested 644 people from Mohalla Hashimpura for offenses under 107, 151, 116. This is really unlawful assembly and breach of peace of the Code of Criminal Procedure. That same evening, in fact, after 8 p.m., 19 officers and jawans of the C Company of the 41st Battalion of the PAC abducted around 45 men from the age groups 16 to 30. Unarmed, most of them were actually young boys, they were teenage boys. Unarmed, all Muslim, from this mohalla, and put them into a yellow-colored bus. It was a PSC bus. Its number is URU 1493. Now, pursuant to their abduction, the PSC truck, rather, was taken to a place called Gang Neher, which is in Muradnagar district of Uttar Pradesh. And at Gang Neher, they made some of these abducted boys stroke men get down from the bus and shot them at point-blank range and threw them into the canal. 3 persons died at the spot, identified as Muhammad Yasin, Muhammad Ashraf, and Zulfikar Nasir. What happened was that some traffic started coming from the other side, and so these guys panicked and went back into the bus. By this time, people inside the truck started screaming, and they began to shoot indiscriminately inside the bus. And several people were injured and killed inside the bus, including one member of the PSC who ultimately became an accused in the case, a gentleman called Leeladhar, who sustained gunshot injuries. On the basis of this first incident at Muradnagar, an FIR was registered. Basically, the 5 people who gave evidence in this case, one of them died, a man called Kumradeen, who was a man who actually got the FIR registered. Thereafter, the truck began to move and came close to the Hindon Canal, where the shooting again started. And it's the picture, in the middle of the night, one by one, these men are asked to get down from the bus, shot at point-blank range, thrown into the canal. A witness, Babuddin, survived this incident, and on his statement, another FIR was registered. So the date of incident is 22nd of May, 1987. On 24th of May, 1987, 2 FIRs are transferred to what is known as the CBC-CID of the UP Police. Investigation is transferred. In 1996, from 87 to 96, remember 45 men have been killed. In 1996, a charge sheet is filed before the Chief Metropolitan Magistrate in Ghaziabad. From 1996 to 2000, these men refused to appear before the court till non-bailable warrants of arrest are issued, and they finally enter appearance, and they're automatically granted bail. Nothing happened after that. Compelling the victims to go to the Supreme Court in 2002, asking for a transfer of the case to Delhi. That happened in 2003, and that's when we all enter the picture. On 18th of May 2006, charges were framed for murder, unlawful assembly, etc., and the trial commenced. We spent some years trying to get a reasonably decent public prosecutor appointed. The state of UP would always send young boys, very junior at the bar, to conduct a case of this profile. And then we had to constantly show them the CRPC and say they do not qualify the requirements of being a public prosecutor under Section 24 of the CRPC. Eventually, after much negotiation with the UP government, a senior public prosecutor, Mr. Satish Tamta, was appointed in the case. It was a harrowing trial. The 5 eyewitnesses who survived this incident, 3 of whom who were grievously injured, were Mujibur Rahman, Muhammad Usman, Zulfikar Nasir, Muhammad Naeem, and Babuddin. They came and testified very bravely as PWs 1, 2, 3, 4, and 11. Naturally, the statements they gave in court were very different from the one-page statement that had been recorded by the CBCID during the course of investigation. They narrated everything that happened to them in great detail, including physically showing the injuries they suffered. Some of them had still bullet marks on their chest, and one of them still had a bullet lodged inside a portion of his lung. All of this was recorded by the trial court. But when it came to the crucial aspect of identifying these 19 men, who had then become 16 because 3 had died, they said, look, this happened in the middle of the night. These men were wearing helmets. They were in uniform. We were 16 years old. We were scared. We can't identify them, which was the honest to goodness truth. You know, indeed, if they had identified them, it would have been a fabrication. The case collapsed from that point onwards, because when an investigating agency relies on survivors for purposes of identification in circumstances like these, you can't proceed, really. It was up to the investigating agency, and it's very simple. When you have cases of custodial torture and custodial death, it's not that difficult to crack down who committed the crime. There are registers. Every time a group of policemen walk out of a police station, there is a Ravangi register, which notes down their having left the police station. There is a register which itemizes the arms and ammunitions that have been given to them. There is similarly a register which records their coming back into the station. These were never produced. In fact, these were destroyed. Destroyed even before the trial was transferred to Delhi. That register was crucial to show that these 19 men were on duty that day, and these 19 men had withdrawn arms and ammunition from the Malkhana and had got into this bus and had gone to Mohalla Hashimpura. You see, this is all diarized. It was all there. It's not like it wasn't there. It was all there, but it was all destroyed. And this is what happens. We've said this in case after case. When policemen investigate policemen, this is the result we get, because they are almost bound to help their brothers, so to speak, and destroy crucial evidence. So the CBCID, which investigated this case for 10 years, really never did any investigation. The only thing it did was destroy evidence. So there were these crucial bits of evidence which was critical. One, URU 1493, the truck in question. It was never seized. There were some senior officers who said, we saw this truck at a time when it was being washed. Actually, what happened was immediately after the incident, because such a horrific incident had taken place inside the truck. In fact, I remember reading an article where somebody called it the Chamber of Horrors. It was really a chamber of horrors. Blood was seen being washed, you know, and below the truck there were these large poodles of blood. Nobody picked that up as for purposes of forensic examination. No photographs of the truck in that state was taken. The truck itself was sent to CFSL for examination 11 months after the incident. And the CFSL records the fact that there are that at many places, it's very evident that there are metal pieces which have been used to cover areas where obviously there were gunshot marks. It was neatly cut, but they had pasted a metal piece over it. So that kind of evidence did come. But when you send the truck as late as they did at that time, there was no question of picking up blood samples or anything from the truck. These weapons of offense, all the post-mortem reports that came in said that the men who were killed on account of gunshot wounds. Everybody, all the eyewitnesses said that .303 rifles were used. Now that was the rifles that had been assigned to these men. Those rifles, not only were they not seized, but they went back into circulation in the UP police, and other people began using them. So this is case property. Not only were those 19 rifles not seized, but look at the impunity with which the state works. It was handed over to other battalions for use in other cases. So we lost that piece of evidence. The eyewitnesses, as I said, could not identify anybody. The logbooks were all destroyed. It is possible that if the state was serious with the investigation, back in the day, in 1987, when the incident had happened, some of these men, who were young boys at that time, it is possible that if they had been put to a test identification parade, they could have identified some people, because they said, tab shayad hum pehchan sakte the, aaj hum nahi pehchan sakte. It was 22 years after the occurrence. They'd grown from being boys to grown-up men. That again was never done. So this was a case where all the original MLCs were destroyed. What we got were photocopies. The original FIR was destroyed. What we got was a photocopy. Also, well, there's a manner in which photocopies can be proved in court through secondary evidence. But even for that, we needed somebody who was familiar with the handwriting of the person who was the original scribe. Those people were all dead and gone. So when you delay cases for 25, 26 years, that's a very real possibility. You lose your best evidence. And they ensured that the best evidence would be lost. When the trial court acquitted these 16 men, it actually gave a judgment which was interesting, because it came to the conclusion that on several crucial aspects, the court believed the eyewitness. So this, on the issue that 42 persons, or 42 to 46 persons were arrested from Mohalla Hashimpura, put in a PSE truck, and the truck, instead of going to a police station, went to first Gangnagar and then Hindon. The court has returned a finding that that actually happened. On the issue that at Gangnahar, Muradnagar, the PSE officials fired at the arrested persons, making them get down from the truck, and some of them were fired from inside the truck. And the PSE Jawans, after shooting these persons, kept throwing these bodies in the upper Ganga Canal so that they would all die. This aspect of the prosecution case has been believed. On the aspect that apprehending exposure of crime, the PSC Jawans diverted the truck from Gangnahar to Hindon River and completed the process of killing and throwing of these bodies in the Hindon River near village Makanpur. This has been believed. But eventually, the trial court grappled with the question. Look, ultimately, this is a criminal trial. This structure, I completely believe. I return the finding that 42 men were killed in this brutal fashion. But I cannot affirmatively say that these 16 men standing here were the men who committed the crime. For that, crucial linking evidence was missing. What was the crucial? It was actually very basic. And as I said, in every police station, there is an entry register and there's an exit register. If that had been produced, it would have been, and timings are given. Place where you're going is given. If the timings is that I have exited the police station, I am going to Mohalla Hashimpura, and I have taken these weapons from the Malkhana, it is loaded, not loaded, whatever else is relevant to the case, all of that is mentioned. And the CBCID report says, we inspected it, but we failed to seize it, but now we don't find it. So it was never produced as evidence before court. Likewise, the doctors say that all the victims died of gunshot injuries. But unless you pick up the exact weapons that were used for purposes of killing these men and send it for forensic examination, you will not get a determinative finding that these weapons were used. These weapons assigned to these men were used for purposes of killing them. That was never done. As I said, the weapons went back into circulation. It was never seized. The truck was never seized. An incident where 44 men are being shot inside a truck. Blood was never seized. There were no photographs of the incident. In fact, the only photographs that helped us was a photograph taken by a very famous, very brave photojournalist, Mr. Praveen Jain, from the Indian Express. He went from the Indian Express, and those photographs were very material because they showed these 44 men huddled under a peepal tree in Hashimpura just before they were made to climb the truck. So that was the evidence of last seen alive. And up until that point, so that is why the judge agreed that all of this happened in the manner in which we said it happened. Ultimately, we got an acquittal. I mean, we lost the matter. You can very well ask, how will it change in appeal? Actually, it will not. But what we are seeking in appeal is not so much overturning a judgment of conviction, of acquittal into conviction, because we realize the limitations of that given the evidence that there is on file.